Hello and welcome. If you're studying constitutional law, you've probably asked yourself this question. When a new law seems to clash with our fundamental rights, who actually gets the final say? Well, that's exactly where the incredible power of judicial review comes into play. Today, we're going to do a deep dive into this, guided by the wisdom of former Chief Justice of India, A.S. Anand, and explore how it evolved into what we now call judicial activism.
So here's our roadmap for today. We'll start with the fundamentals. What even is judicial review? Then we'll trace how court interpretations have changed over time, leading to the rise of judicial activism. We'll look at its most powerful tool, public interest litigation, or PIL. And then we'll get into the really tricky part, the fine line between activism and what some call adventurism. Finally, we'll wrap it all up with the crucial idea of judicial restraint. Trust me, if you have exams coming up, every single one of these topics is pure gold.
All right, let's dive right in. To really get a grip on all of this, we have to start with the foundational role of the judiciary, its job as the ultimate guardian of the Constitution.
Let's start with the big one. This single question is the bedrock of everything we're about to discuss. When the government passes a law, but that law seems to step on the toes of the Constitution, who gets to make the final call? This, right here, is the very reason judicial review exists.
So what is judicial review in formal terms? Well, in a nutshell, it's the power the courts have to put any government action under a constitutional microscope. And I mean any action, whether it's a law from the legislature, an order from the executive, or even a decision from a lower court. They test it against the Constitution, which is, of course, the supreme law of the land.
And you know, the scope of this power is incredibly wide. It's not just about challenging laws passed by Parliament. It also covers executive orders, government decisions, and yes, even the rulings of lower courts. The whole point is to make sure everything, top to bottom, is in line with the Constitution.
Now, this is a point you'll absolutely want to highlight in your notes. Judicial review does not mean judicial supremacy. It's not about making judges the most powerful people in the room. Instead, it's all about creating that beautiful system of checks and balances. The legislature, executive, and judiciary are meant to be equal partners, keeping each other in check so that no single branch can overstep its authority. And this idea isn't new. It has really deep historical roots. In fact, this famous line comes from a landmark American case from way back in 1803, Marbury versus Madison. Chief Justice Marshall said it's emphatically the province and duty of the judicial department to say what the law is. And that single, powerful idea has shaped constitutional law all over the world.
Okay, so that's the what. The courts have the power of review. But the how that power is actually used, well, that's where the story gets really interesting. Because as you'll see, the law isn't static. It has to evolve with society.
Just look at the journey of Article 21, the right to life and personal liberty. This is a perfect case study. Back in 1950, in the A.K. Gopalan case, the Supreme Court took a very narrow, very literal view. But then, over the next 28 years, through cases like the bank nationalization case, the thinking started to shift. And it all culminated in 1978 with the Maneka Gandhi case, where the court's interpretation did a complete 180.
The difference between these two landmark cases is just night and day. In Gopalan, procedure established by law basically meant that as long as a law was passed correctly, it was fine. But by the time we get to Maneka Gandhi, the court said, hold on a minute. It's not enough for a procedure to just exist. It has to be right, just, and fair. It has to be reasonable. This was a monumental shift from just ticking procedural boxes to ensuring real, substantive justice.
And this, evolution. This is really the spark that ignites what we now call judicial activism. The court was no longer just a passive referee. It started taking an active role in making sure those rights written in the Constitution had real meaning in people's lives.
So, what did this new active judiciary look like in the real world? Well, suddenly the right to life under Article 21 meant so much more than just the right not to die. It now included the right to free legal aid if you're poor, the right to a speedy trial so you don't languish in jail, the right to live with human dignity, free from exploitation, even the right to a safe workplace free from sexual harassment. The judiciary was actively filling in the gaps to protect the most vulnerable.
But for this new era of activism to really work, the courts needed a new kind of tool, a vehicle to bring these issues to their doorstep. That tool, that people's weapon, was public interest litigation, or PIL, and it was a total game changer for access to justice in India.
So traditionally in law, you can only go to court if you personally have been wronged. It's a concept called locus standi. But PIL basically threw that rulebook out the window. It said that any public-spirited citizen could now approach the court on behalf of people who couldn't do it themselves: the poor, the marginalized, the oppressed. It literally gave a voice to the voiceless.
And that's exactly why PIL is often called a potent weapon. It transformed the legal landscape, turning individual grievances into matters of public concern. It allowed the courts to tackle huge systemic problems and became this incredible instrument for social justice, designed specifically to empower the powerless.
But, as the saying goes, with great power comes great responsibility. And Chief Justice Anand gives a serious word of caution here. This potent weapon, the PIL, has to be handled with extreme care. There is a very, very fine line between genuine activism and what he calls adventurism.
And here's where the danger lies. A true public interest litigation is a noble cause, but it can be easily misused. People can file political interest litigation just to settle scores with rivals, or personal interest litigation to sort out a private grudge, or even publicity interest litigation just to get their name in the papers. It's the court's job to see through these motives.
Chief Justice Anand uses a brilliant metaphor to explain the proper role of the court. He says the judiciary is like an alarm clock. Its job is to ring loudly when the government is sleeping on its responsibilities. But it's not a timekeeper. It can't step in and start running the government's day-to-day schedule. It sounds the alarm, and then it's up to the executive to wake up and do its job.
And that alarm clock idea leads us perfectly into our final and perhaps most critical theme, the importance of judicial restraint. Because for activism to be legitimate and respected, it has to be balanced with a good dose of self-control.
You see, activism and restraint are really two sides of the same coin. As Justice Anand puts it, judicial activism can't be an unguided missile. It has to be aimed carefully, with a clear target, and always operate within the boundaries of the Constitution. The moment a court oversteps, activism turns into judicial adventurism or even judicial despotism.
Here's another fantastic analogy, this time from Lord Justice Lawton. He said a judge is like a referee in a football match. The referee can and should blow the whistle when the ball goes out of play. But once the game restarts, the referee can't just grab the ball and start scoring goals. That's not their job. Their job is to enforce the rules, not play the game.
So, to wrap it all up, what does judicial restraint actually look like? Well, here are the key takeaways, and these are perfect for revision. Courts shouldn't get into purely theoretical debates. They should leave policymaking to the executive. They can't just invent new rights out of thin air. Their orders must be practical and enforceable. And above all, judges themselves need to be disciplined and cautious.
And that leaves us with this final, crucial question. We know the judiciary must be the guardian of the Constitution. We know it must be the referee. But in an ever-evolving society with new challenges, where exactly do we draw that line between blowing the whistle and starting to play the game? That is the delicate, ongoing balancing act at the very heart of modern constitutional democracy.